Line 1, the Boothroyd Room. Portcullis House, 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 line 1.
Good afternoon. This afternoon's session of the Joint Committee on Privacy and Injunctions is in two parts. The first part we are hearing from the bloggers, and secondly a number of media reform campaigners and commentators. But can I start by welcoming Paul Staines, the editor of Guido Fawkes, Jamie Allen, the managing editor of Holy Moly, Richard Wilson, who is the author of Don't Get Fooled Again and Titanic Express, and David Allen Green, the writer of Jack of Kent. And if I may, at the start, since not every member of the committee is necessarily familiar with every one of the blogs that you write, perhaps each of you could give a brief description of the blog and what is the purpose you see of writing it. Who would like to start?
Okay. I write for Jack of Kent blog. I am also legal correspondent of the New Statesman and media correspondent of The Lawyer. I also happen to be a practising media solicitor. The Jack of Kent blog became quite well known for following libel cases, especially the Simon Singh libel case, providing information to members of the public who wanted to follow that case in a responsible way, ensuring that there were no legal problems about publishing various documents. Since then, I have covered a wide variety of legal and other political matters. For example, unmasking Joe and Harry as David Rose, disclosing the WikiLeaks non-disclosure agreement, and other things. I blog primarily to inform people who are following public debates, and I prefer writing on the internet than writing in print editions.
So my name is Richard Wilson, and I would describe myself as a writer who also blogs and tweets. I've written 2 books. I originally started writing a blog to publicise my book, and that's also how I ended up on Twitter. But shortly after my book was published, a couple of things happened. The first was I got a very scary libel threat over something that I'd written in the book that never came to fruition, but convinced me that there was a serious problem with the way that side of the law works. And then secondly, I found that Twitter has a fascinating dynamic, and I became, through Twitter, I became more involved in freedom of speech issues, including following closely the Simon Singh case and doing what I could to support that. But I think possibly the reason I'm here is that I believe that I was the first person to challenge or possibly even break a super injunction on Twitter. The reason for that was just that I happened to see the Guardian article about the Trafigura case in October 2009, and I happened to be, I think, the person who figured it out most quickly, that it referred to a parliamentary question that had been published on the Parliament website that Mr Faraday, who I believe is a member of this committee, had asked. And I put that information on Twitter, and a lot of other people followed suit, and that was part of the chain of events that led to that super injunction being finished. There's one other thing I want to say, which is just about declaring an interest. I'm appearing here entirely in a personal capacity. I'm speaking only for myself. For the sake of transparency, I should make it clear that I have a non-public facing, non-policy related fundraising role with Amnesty International, but I'm not a spokesman for Amnesty, and nothing I say should be taken as any indication of Amnesty's views.
Okay, thank you.
I'm Jamie East, founder, managing editor of Holy Moly, the world's most amazing celebrity gossip website. And I guess that's why I'm here, because everyone loves reading about celebrities, whether the celebrities want you to or not.
My name is Paul Staines. I edit the Guido Fawkes blog together with Harry Cole, who's my junior. A number of you have featured in it, so I suppose you should be familiar with the output. We have 50 to 100,000 readers a day, and we cover politics and the skullduggery that you lot get up to.
Good. Michael Dobbs, Lord Dobbs.
Can I ask you, I'm being a naive sort of fellow, how do you make your money? How are these blogs financed? How much do they cost, and where does the money come from?
The Jack of Kent blog has probably made about £12 in 4 years from Guardian, from Google AdWords. I do that completely voluntarily.
Right.
It's a template system which is from Blogger. You just basically fill in the gaps and type in the spaces, and it publishes it. For the News of the World and The Lawyer and various other places, you're just paid in the same way any freelancer is.
Right. So you don't take any money out of your
No.
blog? May I ask, do any of you take any money out of your blog? I mean, Mr. Staines, I mean, it seems to me, reading the biographies, that you're probably pretty much a full-time editor on this. Can I ask you how the website works, how much it costs and how much...
The actual cost of the hardware and the servers, etc., is probably in the order of £5,000 a year, because it's a commercial site. As you can see, there are loads of adverts all over it. When you have a mass market product, you can make a living. And I'd say about 50% of our revenue comes from acting as story brokers. And some of our best stories appear on the front pages of newspapers without our byline, but our name is on the cheque.
Right. Could I actually, just to elaborate on that, you get income from various different sources, therefore, as you have
we get probably, these proportions are approximate, I haven't looked at it, probably about half the revenue comes from advertising, just normal commercial advertising, the same as you'd see on the Daily Mail website, and the other half probably comes from acting as a story broker and giving stories to the tabloids in general. And I occasionally write for the broadsheets.
Similar. I sold half the company to Endemol UK earlier on this year. Again, probably about 60% of the money comes from advertising revenue. We also provide white label services for third parties who just want some celeb stuff writing, so we write it, again, without our byline.
So this is, I assume that it started off rather like Miss Alan Green's, that it was almost a hobby that's grown up into a big business.
Yeah, I started on a whim.
Right. Dare I ask how much in terms of salary is taken out, not necessarily by you, but the people involved in it over the course of a year?
I'm not telling you.
Why not? What's your problem in telling us? Can I?
Because that's my salary.
Well, I mean, I thought you were an intrepid searcher after truth. And it seems a little strange that you should be coy about your own personal...
No, not really.
No?
I don't put myself out there to be a public face, so...
OK. You can't call it... Mr. Staines, do you have a different point of view about that?
It's a six-figure business. It's about order.
OK, fair enough. Thank you.
OK. George Eustace.
Thank you. One of the arguments that we're trying to get to grips with here is whether it's actually worth improving regulation of newspapers, because one of the things people say is, well, the bloggers will just leak everything anyway, so there's no point. I just wanted to try and help us get to the bottom of that, whether you can say how many unique followers you've actually got on each of your websites, in terms of your readership, and whether you know that information.
Yes, I have. I've got about 19,000 people who follow me on Twitter, and I will average between 300 and 3,000 hits per day, depending on the type of article I follow. A lot of that will be people who just happen to see it because it's been linked to by somebody else because it's particularly newsworthy. It's not, in my experience, like a newspaper where you have fairly consistent readership levels. It usually does peak when you've got something worth promoting. As regards its relationship with newspapers, my view is that Twitter is highly effective for distributing worldwide and immediately information which is provided to it by somebody else. And in respect of the super injunctions issue, the two sources of information which got treated around the world immediately were not tweeters. These are people who put the information there, like meat in a piranha tank, and then realised what Twitter could do to send that information around the world. And so with social media, it does tend to peak when there's something interesting, and something highly interesting, like an alleged super injunction, will lead to a hell of a lot of hits.
I've got around 4,000 followers on Twitter, maybe a couple of hundred hits a day on my blog. Twitter's probably more important to me, and I'd echo what David said. What's significant about Twitter and how it differs from a lot of other media is that it doesn't take very long to build up a big audience. If you happen to have something of interest to say, that you can quickly suddenly find yourself with tens of thousands of followers. And that's why I think the regulation problem is such a challenge, because you never know where the next person breaking a super injunction is going to come from, because if they just happen to be the person that has that information at the right time, then they can quickly find an audience.
Yeah. The number of followers is strictly irrelevant. If you have got a single tweet which is of any interest, it will go around the world very quickly, regardless of how many followers that particular tweeter has.
I'd maybe compare it to graffiti. It's like anyone can write graffiti on a wall, but now potentially anyone in the world can see that wall, and that's the challenge, I think, for trying to control it.
I've got about between 55 and 60,000 Twitter followers across a number of accounts, which serve about 6.5 million page impressions a month to about 1.6 million people. I kind of agree there. If you either do it or you don't, there's no real... The size of a blog doesn't matter, because the blog can go from 0 to hero within about an hour, depending on what they're writing about. The same can go for a Twitter follower or whatever. So the scale of the blog is largely irrelevant. It's the fact that they're a blog that is relevant.
I used to think Twitter was a fad that wasn't going to last, but now I've got 50,000 followers on Twitter. I'm very enthusiastic about it. We have 50 to 100,000 daily readers, impressions. It can, at its peak, for instance, during Smeargate and the Damien McBride emails, go to 100,000 an hour. I think my traffic is sort of comparable to the Spectator or the New Statesman.
And would it be fair, as all of you have said, intrinsically you've got quite low levels of readership. Would it be fair to say that when you get those big spikes, it's largely driven by mainstream media? In the case of Damien McBride, for instance, that was suddenly on Sky News, it was running on the broadcast bulletins, it was in all the newspapers, and that therefore drove traffic to you. And perhaps in the case of a footballer who's got an anonymised injunction, the fact that that exists creates a sort of hunger that you then step in and fill. Is that?
I think search is the biggest source. So people will search for Damien McBride or whatever was the story of the moment, and they'll find you that way. And Google's very intelligent and knows where to go. So when we do have those kind of spikes, it's usually the key word that's the cause. And sometimes that key word might be Guido Fawkes' blog because they've seen us on TV or something.
In my experience, stories which the mainstream media are not touching. So, for example, libel cases where newspapers invariably go into radio silence, I will responsibly publish the materials relevant to it, and I will often be the only source on that libel story. And that's the same for other things which are legally sensitive. So it's the opposite of what you're suggesting in your question. Some bloggers have peaks because of things not being covered in the mainstream media, not as a knock-on effect of things being in the mainstream media.
Can you just define the word responsibly in that context?
Yes, of course. One has obligations under the general law of the land. I have specific obligations as an officer of the court. When I'm publishing court materials, I make sure they are materials which I have obtained or could obtain from the Public Record Office. I publish within the law of contempt and of libel. And I would say, like many other legal bloggers, we are extremely responsible about how we present legal materials. Often more responsible than tabloid journalists.
Okay, thank you.
Just coming back on this similar point about whether it's worth our while trying to improve regulation of newspapers. The other thing that's quite often said is that there's a kind of pecking order of credibility, that broadcast media is the most regulated that we've got, but it's also the most trusted by a country mile. Newspapers are not really trusted as much, but they've got the sort of Wild West culture and a more flexible regulatory environment. And then bloggers at the end don't have any real constraints at all, but the levels of trust are even lower still in terms of what's written. Do you think that would be fair?
Not quite as low as politicians, though, is it? I think, with my blog, it's not Reuters, so we have a lower threshold for reporting some things, and the nature of gossip, which is what we specialise in, is that often you have to go with one source. But blogging in general, science bloggers have more credibility than generalist science reporters on broadcasters. And, much as it pains me to say, I think Dave Allen Green is quite good at legal reporting, better than some generalist reporters in the law courts. So it's not always the case.
I would say that blogosphere is very similar to how one would imagine 19th century city to be. a lot of it is based on reputation. It's not an enforceable reputation. You don't have a right of action to credibility. You can't go to court and defend and vindicate your reputation. It can be lost in an instant if you do something which is misconceived. But the one thing bloggers can do routinely, especially legal and science bloggers, and increasingly policy bloggers, is link to sources. And that so helps credibility. If you do not believe what I am telling you about a case or the CPS guidance, then you can link and look at it for yourselves. And so, yes, you are right, there is that hierarchy. People feel more comfortable with broadcast media than with newspaper media. But there are certain bloggers who do have a great deal of credibility, which can be lost in an instant. But that credibility is often built up by the bloggers doing things which only bloggers can, which is actually being transparent about where they're getting the information from and allowing the interested reader to follow the links to see that information.
I would echo that, and I think it is about track record, and people trust the BBC also because the BBC has been around for a very long time and has a very impressive track record that it can point to. I think over time you'll see that with certain bloggers, perhaps even a couple of the ones sitting beside me here, building a reputation for credibility just through their own efforts over time.
Ben Bradshaw.
Paul Staines talked about the brokering relationship that he has with newspapers. It's really, does it also work the other way around? There are sometimes times, this is mainly a question for Paul and maybe for Jamie East as well, that there are stories that the papers won't print and the individual journalists or papers come to you knowing that you're more likely to put them on your blogs and therefore get them into the public domain.
Yeah, absolutely. It's very much a working relationship with from editors down to showbiz reporters, from my part anyway, down to just newsroom people. It happens less and less nowadays, I think. But certainly, kind of 4 or 5 years ago, sites like Holy Moly or Popbitch or several similar kind of size websites would be used as kind of the testing ground for a story, which papers would then report on because the nasty internet people had done it. So it made them able to write about it. The fact that we'd written about it, which worked well for both parties for quite a while.
I think journalists quite often, when they're having problems with their editors, will give us half the story to keep the story alive, or to keep the story going from one Sunday to another, or encourage us in some way to focus on something so that they can turn to their editor and say, look, the bloggers are on it.
And what's the financial relationship when it's that way round? I mean, how does that transactional relationship work?
There is no financial relationship. I might buy them a pint.
Yeah, I won't even do that.
Lady Bonham-Carter.
My question was asked. I was wondering how the financial work.
Just for Mr. Green, I'm quite interested in your saying you're always within the law. As you will know, disclosure in a legal case is for the purposes of the case only. And do you keep within that?
Absolutely.
And what about copyright judgments? Do you keep within that?
I usually link to judgments rather than set them out myself. I usually link to judgments. There's an excellent site called Bailey which allows you to link to almost all judgments. Yes, one has to be quite mindful, but I'm not unusual in that. There's at least 2-3 dozen legal bloggers who do very similar things, many of whom are qualified and experienced lawyers in their own right. It's just like being somebody who would like to inform a public debate, especially over libel and privacy, and I've written quite widely on privacy and tried to explain the nature of some of the injunctions and why they are important to have. The thing is that it is possible to self-publish and add to a debate when you have actually experience and are willing to put the effort in to put the story into the public domain. And as in respect of the previous question, I have journalists coming to me, but not for cash, I'm not at all interested in that, but there are a number of people who are well known as serial libel abusers. But you cannot mention them without having a claim form. I won't take advantage of parliamentary privilege now to name them, but they do exist. And I have, on a number of occasions, allowed stories to get into the public domain which could not go through a newsroom's legal department because of the sheer commercial risk of publishing that story. So in a way, bloggers can help the mainstream media, but not only in brokering stories on a commercial basis.
Could I just add, since my relatively marginal involvement with the Trafigura case, I had a number of journalists contacting me saying, we wanted to write more about this, we wanted to say more about this, we couldn't do, and hoping that I might be able to do something as a blogger. Actually, bloggers are just as much liable to the law as everybody else, so I haven't always been able to do that. But there's a clear sense there that bloggers could be helping to fill a gap which is created by the messy regulation system we have.
I'm sorry, do either of you have leaks from lawyers?
Not from lawyers. No.
No?
I would be very surprised. I mean, all the lawyers I've dealt with, including David, in this capacity, I think they behave themselves quite well, to be honest.
I've never once had a lawyer approach me to legal storage. It's for clients who then want to sort of see if they can get this into the public domain.
Usually it's journalists, very frustrated journalists, that they can't get stuff past their editor because their editor is too scared of libel or whatnot.
But can I get Lord Miners?
Good afternoon. Thank you very much for joining us. I'd like to ask you a little more about legal complaints. How often have your organisations been the subject of legal complaint, or, as Mr. Wilson said, legal threat regarding what you have blogged or have indicated you intend to blog on? What were the outcomes of those complaints? Your observations on the process, and finally, what, if any, actions have you taken to protect your blog from being seriously undermined by legal intervention, such as location or capitalisation?
I've probably had about over the past 5 or 6 years about 30 to 40 kind of threats of, in some way, shape or form, ranging from a sarcastic letter through to issuing proceedings. And you have to take each one on its individual merit, really. And for a blogger without any kind of financial backing, as I was originally, it's quite a scary thing to go through, because you don't understand what the rules are. There is no there's nowhere to go to say what was I supposed to have done, or what on earth do I do now. But you learn really quickly. So I've been through the mill quite a few times. I've never been sued. I've made donations to charity, or I've reached a kind of agreement with certain people as to maybe not to talk about that particular instance again. But generally, you just have to think on your feet and try and do it in a way that doesn't bankrupt you before you've even begun. Because the second that you're without prejudice in the subject line of your email, you're heading down a slippery cul-de-sac of remortgaging your house.
Over the 7 years we've been going, we've had dozens of letters before action, lawyers' emails, legal complaints, etc., etc. At the outset, I should say, if we believe on reflection that we've got it wrong, we do take it down, and that usually solves the problem for most complainants. We've never been successfully pursued through the courts in the end. Zach Goldsmith and Jemima Khan, this is before she was a campaigner for the freedom of the press, obviously, did injunct me in 3 different jurisdictions. On an ex-party basis in Dublin, they convinced a High Court judge that I'd hacked their emails. They didn't produce any evidence to that. The judge gave their counsel a severe telling off. Should say that in Ireland, you're not allowed to get into whom it may concern injunction, as you are here. In Ireland, you have to have a specific person who you're injuncting for a specific reason, and they have Article 6 of the European Convention of Human Rights in their constitution, just like we have, which seems to be the basis of all these privacy injunctions. Those injunctions have fallen by the wayside, so I would say we've never been successfully sued.
In 4 years, I have never had a letter before action, and I've only ever had one bare legal threat, and I referred that person to the hallowed case of Arkell against Preston straight away. The problem, which is often the case with bloggers, is that powerful individuals go after the internet service provider that hosts the blogs and often get posts taken down without even engaging meaningfully with the blogger to find out whether there's a right of reply or anything which would actually be a constructive approach. Firms of claimant lawyers who commercially tout themselves as dealing with so-called reputation management actually sell this as a service. And it's illiberal, and the new libel reform bill should actually attack this problem by making it more difficult to threaten a libel case. So libel is a problem for bloggers, and legal threats is a problem for bloggers, but that said, almost all responsible bloggers, even on political and legal matters, can write responsibly and are not threatened by libel claimants.
I've had 3 libel threats, one from an arms dealer, one from an employee or former employee of Carter Ruck, and and one from the Member of Parliament for North Oxfordshire. And I've always just taken the information down. If I had to fight a case, I would go bankrupt. That would be the end of the story. The most serious threat I had was over something I wrote in my book, and I would have been prepared to fight that one even if I'd gone bankrupt. Happily, I didn't have to.
Lord Jambro.
I think most of this is your reaction to the law of libel. Can I get back to the law of privacy? And whether, as the law has been developing, this has affected the way you operate, whether you take legal advice on issues to do with privacy at any stage, and whether you've ever pulled a story for reasons of privacy as opposed to libel.
Well, I'm not aware of Parliament ever debating a law on privacy. Could you explain that to me?
I'm thinking of the impact of the Human Rights Act.
Article 6.
8 and 10.
The right to a family life, that one.
The right to privacy.
You have to help me here. I'm just not aware of the right to privacy.
Well,
which law are you? I don't know.
The right to privacy is now established in law as a result of the
judges making law from the bench ruling.
Well, as a result of Parliament passing the Human Rights Act incorporating the European Convention.
I'm not a lawyer, but I don't remember Parliament ever debating a right to privacy.
I think it actually did come up during the course of the debate on the Human Rights Act, which is why Parliament...
As you can see from my answers, I don't pay any attention to the right to privacy, which I'm not aware of it being in
follow that if Parliament did discuss it and debated it and passed a law, that you would then obey it?
I don't think so. I don't think there's any public interest in keeping the truth from the public.
I actually, for once, share Paul Staines' view. There isn't a law of privacy. There is a tort of misuse of private information. I think the House of Lords in Wainwright made it absolutely clear that there is no self-standing law of privacy. For example, there is no way anybody can defend their own personal space using the tort of trespass to a person. But there is a tort of misuse of private information, which is basically the old law of confidentiality supercharged by the Human Rights Act, which gave further effect to the European Convention and recognised that it would have effect by enacting Section 12 of the same Act. So you do have this misuse of private information. Super injunctions, supposedly, are a new thing. In fact, the jurisdiction of the Court of Chancery to give injunctions to protect confidence was always wide-ranging. The only difference is that Article 8 made it possible to grant one of these in respect of rights to privacy. But the problem for bloggers, unlike newspapers, is that we are not given notice of the terms of those injunctions. And so you are in the awful situation, as a blogger, or anybody who's self-publishing, to know, or perhaps know, or suspect, or be told that there is a super injunction, and if you publish something you might be in breach of it, but not to have been given any notice of the terms of that injunction. That must be an unsatisfactory situation because it inhibits free speech without people being able to regulate their own conduct in knowing what to publish and not to publish. And so we have this strange situation where we do have a sort of privacy law which sort of protects privacy rights, which sort of is effective, but only if you have notice of the terms of that privacy injunction. And as more and more people self-publish, that is not a sustainable situation, it seems to me.
So what's your answer?
The answer is I have never been threatened with a privacy action because I don't write about people's private lives, so it's never been a particular issue for me. But I have written a great deal about privacy law, and I have followed the super injunction debate quite closely, and have realised that it actually is an unsatisfactory position for the blogosphere because how do they know they are breaking the terms of a court order?
Bishop.
Many countries have signed up to the European Convention, and Article 8 does grant a right to privacy to everyone, is the expression in the article. Could you tell us something about when somebody is accorded so-called celebrity status, how that right of everyone to privacy gets qualified by the attribution of celebrity status?
From my point of view, if the celebrity has used part of their private life in order to become a celebrity or to maintain celebrity, then I tend to ignore that right to privacy. Put quite frankly, yeah. If they're using an example, if a celebrity's got married and has sold the rights to their wedding for hundreds of thousands of pounds, then I find it a bit hypocritical then to not be able to discuss the fact when they're caught having an affair or something like that. So was that even the question? Sorry if I've got...
Well, I can see the specific case of hypocrisy or whatever that can arise in those circumstances. But somebody who just happens to be a celebrity because they happen to be a well-known footballer or pop star or politician or whatever, but who hasn't engaged in that sort of activity, engaged in purely private activities, not directly connected with their public role. On what basis, given the conventional right to privacy, does one have a right? Princess Caroline case was a classic example in the European jurisdiction. She was simply photographed in the street, and the European courts have upheld that she had a right to privacy, even though she was known as a prominent member of the royal family.
Well, I kind of argue against that, really. I mean, being photographed. If you're with your children, fair enough. If there's there are many celebrities. There are more celebrities that manage to maintain a private life just by not being public celebrities than there are celebrities that actually choose to engage in the tit for tat with the tabloids and with the blogs and with the websites in order to maintain this illusion of amazingness. If that's even a phrase, you don't see your Brad Pitts or your Tom Cruises or whoever complaining about being photographed in the street because they just get on with their lives. The people that complain about being photographed in the street are the people that generally have things to hide, or are missing out on commercial opportunities in which they would otherwise be gaining from.
A very specific question, because he's in the news at the moment, Hugh Grant. Because he grants an interview to a newspaper to publicise a new film from which the film company obviously benefits, he benefits, and the newspaper benefits, does that then mean that he has made himself fair game for every aspect of his private life?
No, not really. No, because he's always made a very public stance for many years that he does not like tabloid intrusion or paparazzi or press photography. So Kate Moss is another very good example of a huge celebrity that does actually, believe it or not, maintain quite a good private life, and with the very rare exception she gets caught on the wrong foot. Her child has never been photographed in public, except for at her wedding, when the mother chose to allow her to be, because she was part of the wedding party. So you can make that decision, and Hugh Grant's an example of someone who does make that decision right from the off. Whereas there are many other celebrities. You can't do a little bit. You can't do a magazine spread with your kids in your home, smiling sweetly for the cameras, and then cry foul play when a photographer takes a picture of you walking down the street. It doesn't quite work like that, unfortunately. So make the decision from the beginning, not halfway through, when it stops you from making money out of it.
I deal with celebrity politicians, and I think there's often a public interest case for looking into their private lives. Tom Watson's complaining that News International, News of the World, was following him around at Labour.
I don't want to go into individual cases under the guise of parliamentary privilege unless there is a direct relevance.
Well, he's complaining about a gross invasion of his privacy, being followed around by...
No, I don't want to use this committee to air allegations which you would not want to make outside of the committee. Lady Bonham-Carter.
Mr. East, at the beginning of this session, said because he was not a public person, he was not willing to tell Michael Dobbs his salary.
Yes.
Then Mr. Stain said he didn't believe there is any such thing as privacy. Now, would Mr. Staines publish Mr. East's salary?
Of course he would. I don't think my readers are interested in this. They're interested in your expenses, but not his salary. So no, it wouldn't fit my audience.
I think the best way of looking at this is not to look at the celebrity or otherwise of the person affected, because that's not how the law works. Although, yes, Article 8 has effect in English law, it has no direct effect. It has to hook itself onto some part of substantive law, either civil law, such as confidentiality, misuse of private information, or even the criminal law, like harassment. And those areas of law attach themselves to the information. So the question really, I would suggest, is not the celebrity of the person affected, but the type of information which is actually going to be disclosed, regardless of the celebrity of the individual. And then you will be able to protect core privacy, and almost everybody would agree that people are entitled to private life. I would say that thinking about the celebrity of the person affected is not the right way of looking at it. You've got to look at the information which is going to be published.
He doesn't agree.
Francis is right. I mean, Nigel Griffiths caught him with a prostitute on parliamentary estate, and he got a partial injunction on that. I thought that was a disgrace. He shouldn't have been allowed to get away with that. I think the public has a right to know what their politicians are up to.
But, I mean, from your answer you gave earlier, you essentially seemed to suggest that you felt that you should be able to publish whatever you liked on the basis that it's true, and that it's up to you to decide whether or not it's publishable, and no individual has a right to suppress anything that is true. Is that correct?
I think broadly, but I don't exactly agree with what you just said, but broadly if it's true and there is a public interest, I don't think that freedom should be curtailed.
And the public interest is determined by you?
No, there are standard criteria for determining public interest which come up in court all the time.
What definition of public interest do you use? How would you yourself
you have a working definition of public interest. If there's public money at stake, if it's a public servant who is doing something wrong, I'd say the presumption is that exposing wrongdoing by a public servant with public money on public time, it is in the public interest so to expose.
Well, supposing you quite deliberately breach an injunction that you know to have been given because you don't agree with that injunction, you think there's a public interest in it there, don't you think that it's not in the public interest, your definition, your understanding of the public interest, to breach court order?
I don't think it's against the public interest to tell the truth.
No, that's you're getting away with it there. Surely you have, as a member of the society, a certain regard for the law under which you live and conduct your relations with everybody else. If you breach an injunction quite knowingly, just because you think that it will interest your readers, don't you think that undermines the public interest in the broadest, most general sense that you can have it?
Well, when we have knowingly breached an injunction, it's a calculated risk, isn't it? You know, if we think, and some of these public injunctions are quite trivial. You know,
a risk of what?
Well, it was quite trivial, all these footballers getting injunctions to stop us naming their mistresses. I don't think there was any public interest served in that. I don't think the drafters of the European Convention on Human Rights ever imagined in their wildest dreams, in the 50s, when that law was designed to protect people in Soviet countries that were being under persecution of oppressive governments, that it's going to be used as a fig leaf to cover up their extramarital blushes.
Never mind about Soviet countries. In this country we have a legal system to which no doubt you ascribe, and a judge has the job, in a particular case, on a set of facts, of balancing the freedom of expression in Article 10 against the right of privacy in Article 8. And he comes to a decision on all the facts that he knows. You are prepared, as I understand it, to say, well, he's got it wrong, even though you don't know everything. And you are prepared to breach an injunction, and you still consider that you're acting in the public interest. I don't follow the logic of that, or the morality of it if it comes to that.
But then we'll agree to differ.
Well, in other words, you can't answer that question.
What's the alternative, though? I mean, if a judge, for example, in the Trafigura case, passed a law suppressing a confidential leaked company report which appeared to show that the company knew that its toxic waste could have caused deaths, and at the same time the company was denying that it caused deaths, even though it had been widely reported that there were 15 deaths in connection with this toxic dumping incident. And a judge passes an injunction saying nobody's allowed to talk about that, and then we have a news story on the Guardian website saying we've been gagged from reporting Parliament. Are ordinary people supposed to sort of just sit there and nod and say, well, the judge knows best? Because I think that's not the tradition of our country. I can see the conflict that you're highlighting, but what do we do if a judge makes a decision that appears to be a really, really poor and unjust and illegal decision?
Appears to you when you haven't heard all the evidence, of course.
Well,
nor do you know the length of time that injunction has been imposed for. I'm not, the Trafigura case is a very interesting case. It gets us away from footballs. But there a judge passed or made an injunction which was breached by a member of Parliament, who unfortunately isn't with us. Don't you think it's the judge who should decide?
I think you're absolutely right, and I think one of the most interesting questions that came through before the session was to do with the public interest in the rule of law. But I'm going to make an embarrassing omission. I looked up the rule of law on Wikipedia, and it referred to some other sources, including the International Bar Association and the UN. And the UN definition of the rule of law makes it very clear that open and transparent and accountable justice is integral to the concept of the rule of law. And I think one of the reasons we have this problem is that the super-injunction phenomenon is an example of secret justice. And so I think a judge who passes a secret edict in a secret hearing is undermining the rule of law more than a blogger who finds out about it and seeks to challenge it.
You talk about open and transparent justice, and we'll all run the flag up for that, but you must admit there are exceptions to it. For example, when you're dealing with children. And once you admit that there are exceptions to it, isn't it for someone who knows all the facts and has heard the evidence and knows the legal principles to come to a conclusion? Well, I'd be interested in Mr. Greenfield.
My Lord, I think the best way of looking at this is to realise that people on Twitter and in the blogosphere do not breach court orders by themselves. I'm not aware of any example where some tweeter or blogger has gone off, found out the terms of a court order, and has then gone forward to actually just do it under their own volition. In all the examples of which I am aware, it appears to me that somebody, possibly within mainstream media, has leaked that information or has put that information into the public domain in a jigsaw way and then left tweeters and bloggers to get on with it. And it may well be that in respect of certain tweeters and bloggers you will have arguments about, well, I know the public interest better than you. But the simple fact is that once the decision is made to put this information into the public domain, that is what will instantly follow, because that is what Twitter and the blogosphere are like. They will take this information and they will publicise it and they will analyse it. The key question is the responsibility of those individuals who are passing that information to the blogosphere and Twitter, or publishing articles which it takes about 30 minutes at most to decode, such as the Trafigura story. I did not breach the Trafigura injunction. But once I saw the article published by The Guardian, I was able to work it out for myself, I think possibly quicker than Richard published it. It was just possible to do it. So putting the onus of justification on the bloggers and tweeters, I think, may be a misguided approach. That is what will happen if somebody themselves breaches a court order or attempts to frustrate a court order by putting that information into the public domain by one way or the other.
Earlier on that there's no tradition, I think, if I understood it correctly, of accepting that judges are most of the time right. Would I be right in thinking that, as far as you're concerned, there's never a justification for a so-called super injunction? There couldn't be.
I wouldn't say that was a fair characterisation of what I said. I said we don't place blind, absolute faith in figures of authority. We question and we criticise and we debate. But on the question of should there be a super injunction, I think on balance, a society where there can be super injunctions and they can be abused in the way that they've been abused so horribly the last couple of years in this country is worse than a society that doesn't allow courts to pass secret rulings about this in this way and then deals with the consequences. I think we have to deal... It's the lesser of two evils. I accept that there are cases where it can be harmful for information to get out to in the public domain, and I think we need to do what we can to try and prevent that, but I don't think super injunction is an appropriate solution.
And when you have in fact been acting in a manner which appeared to breach an injunction, and whether you realised it or not, what was your motivation for this, and how were you so sure that you wouldn't be prosecuted for what you did?
I was not at all sure that I would not be prosecuted, and I think it's very important for the committee to understand that, along with, I believe, many other people who took the decision to publish that information, I was aware there was a risk I would find myself in court. And I think my thought process was, if someone wants to put me on trial for publishing the text of a parliamentary question on Twitter, so be it. And maybe I would be wrong, but I think that was the case. And I think from speaking to other people that we did know, it just seemed an outrage. It seemed completely absurd.
Yeah.
And that was the motivation. It just seemed wrong.
You're referring to the Trafigura case?
I'm talking about the Trafigura case, yeah.
Specifically that case?
Very specifically that case. I think that case does stand out, and I think this is a case of confidence rather than privacy, and I accept that there are important distinctions. I think the cases of confidence I'm probably more concerned about, because we're not talking about an individual person. You're talking about a large company trying to prevent embarrassing information coming out. I've got a lot of sympathy for the desire to protect people's family life. You know, I would take a slightly different view from other people on this panel on that. But even in those situations, I would say that I don't think a super injunction is appropriate.
Martin Hall.
Yes, I was wondering if we pull back to something you said almost in passing, which was potentially quite important actually, which is that you seem to suggest in the case of the footballers that the public interest test shouldn't be applied to the revelatory story, it should actually be applied to the injunction. So in other words, you would ask somebody trying to bring one of these injunctions not just to prove that there was their right to private and family life, which is the phrase in Article 8, but that the granting of the injunction had to be in the public interest on a wider basis. Is that really what you meant?
I think you've summarised it quite succinctly. I mean, everyone recalls the Trafigura case. I wonder if people remember the Merrill Lynch memorandum about Northern Rock, where Merrill Lynch produced for the Treasury a memorandum saying that saving Northern Rock might cost $50 billion. The FT published it. Within an hour, it was injuncted and removed. I think when $50 billion of the public's money is going to be spent, it's sort of in our public interest to know about it.
Forgive me, but that's going back to the one that we all agree on, that the story itself was clearly in the public interest.
Well, the judge didn't agree, did he? So
well, but no, indeed. I mean, that's a genuine issue. But I suspect you'd have a lot of sympathy for that view here. But the case you actually mentioned was the one of the footballers, where you were, I think, saying that it wasn't sufficient to prove that their private interest was genuine in keeping something confidential, but there had to be a public interest in keeping it secret. Is that right?
Yeah, I think you summarised my position.
Okay, in that case, can I ask a little follow-up, which is that if if we managed to define the public interest sufficiently generously, so that it clearly excluded skullduggery and hypocrisy and so on, and if we were sufficiently limited in our interpretation of privacy, so that even you were happy that there were some stories that shouldn't be made public because they were clearly private, clearly not in the public interest, would you see it, do you think it's right for there to be any statutory or legal framework to protect those kind of stories from publication at all?
Well, I'd look at the United States where they have the First Amendment, which would prevent any of this kind of suggestion of privacy injunctions happening, and that country seems to function quite well, even though it has the First Amendment. And I don't accept that there should be privacy injunctions to protect people from embarrassment. There's loads of things I don't want my wife to find out, but I'm not going to get out an injunction to prevent her finding out. It seems to me that it's not very often in the public interest. Perhaps in cases of family law, where it would be prejudicial to the children, or perhaps in sexual offence cases, maybe, that's a different argument. But in most circumstances, I cannot imagine privacy injunction being in the public interest.
Okay, well, to just support Lord Thomas's point a little bit then, if even in that very narrow set of circumstances where children were involved and there was the interests of completely innocent family involved, would you then support some kind of statutory or legal framework to enforce that?
If it was very narrow, but I think the ECHR was originally drafted with something very narrow in mind, and I don't know if the committee's studied the situation in Ireland, where although there's not a body of law and cases as much as there are here, they apply that provision in the ECHR to journalists who steal pictures off the mantelpiece, when there's been a death, or hack into voicemails, etc. Those kind of things. They don't. The right to privacy, the right to family life, isn't said to include, a right for the public not to know that you've cheated on your wife.
Lord Gold?
What's troubling me is this really. There will be worthy cases, and you've given a couple of examples, Trevor Gura, that Merrill Lynch example a few moments ago, where it's very easy for us to listen to you and to see how you justify going out on the white charger, bringing information into the public domain for the public good. You're not elected to do that. You've chosen to put yourself in that position. But you've also told us this afternoon that you are used a bit, that you are you have a tremendous power. The press sometimes give you stories which they don't feel able to publish for one reason or another. If you've found a good story, it will go around the world immediately, however many followers you have. In one case, you chose to ignore the rights, the decision made by a judge who had heard the case. If someone complains, we hear you take it down. What we haven't heard is whether you then publish an apology or a statement that the original statement was wrong. What I'm concerned about is that it's all very well putting forward a position of responsible blogging, but what if you aren't responsible? What if you use this phenomenal power for your own interests? You just go out on a cause of your own. How do you protect people from that without any kind of regulation whatsoever?
We have the laws of defamation.
Might be too late.
Lord Gold, it sounds to me that you are very closely describing the conduct of John Hemming MP. Great power, no responsibility. Also within the press, great power, sometimes little responsibility. I think it's wrong of you, if I may say so, to characterise the blogosphere in such a general way. I have never broken a court order, knowingly or unknowingly. The vast majority of bloggers are responsible. Yes, we do get our sources from somewhere else. Yes, we do act responsibly. But there's no way you can characterise the blogosphere in a way which is not also true of the political correct class and the mainstream media.
But we're not looking at that right now. We're looking at this law of super injunction, or what is happening with super injunctions, and we are considering the position of blogging and the ability of social media to drive, open a new frontier, really,
well,
and we want to think about whether there's any need for some sort of regulation or rule.
Well, I would suggest, if I may, that of the estates of the political class, the mainstream media and the blogosphere, of those three, the blogosphere has done the least to break the terms of super injunctions, and has only done so when one of the other two of those estates has done so. As regards regulating social media and the blogosphere, as you will of course know, the origin of confidentiality is the law of equity, which never acts in vain. To try and close the stable doors once the mainstream media or the political class have decided to use the blogosphere to put the story into the public domain, I think is futile.
I think there's a comparison between what has happened on Twitter with super injunctions, when a large number of people, not just me, not just a couple of us, but a large number of people all decide that a particular ruling is so absurd or so unjust that they're prepared actually to risk the wrath of the law to break it. There's a comparison between that and other occasions in history when large numbers of people have chose to break the law specifically with the intention of highlighting problems with the law. In a very, very small way, and I'm not claiming we're anything like as significant, but the mass trespasses of the 1930s, when people just marched onto the land and said, we would like to be able to go for walks in the countryside, please. It was civil disobedience. I mean, and I agree that's never taken lightly, but I think that's what you've seen in some ways online, that people are trying to open up the public space for freedom of expression in the same way that people were trying to open up the public space for freedom of movement in the 1930s.
I'm not being judgmental. All I'm trying to do is to see whether or not we have the right balance.
I mean, we could be prosecuted. I could be sued for libel. I could have been, I guess, I don't know, but I guess we could have been put on trial for contempt of court for breaking a super injunction. So I don't think we're in this weird legal black hole outside the reach of the law. I think that's a perception that's actually mistaken.
But that doesn't mean that you provide protection for the person whose name or activity has already been published. You might be worthless if someone sues you for libel.
I would be.
So what good is that?
Well, that's the problem with libel law. I mean, I think...
But you're praying in aid libel law to protect the public, and now you're saying it doesn't work.
Yes. It's a messy situation.
You're not helping me.
Okay, well,
how do you get the balance right?
Okay, well, I think there should be a small claims court for libel to deal with people who have smaller audiences. I think that you could deal with it. I think you could improve it. I think it's true that you have to deal with injunctions and libel together because it's part of the same picture. I agree it's a regulatory mess. And I think sometimes in the situation of regulatory mess, people find themselves having to make these crazy judgment calls. Should I put a parliamentary question on Twitter or not? Or do I just let it go by? Because it feels like a bit of a crisis situation that we're in.
That's the right time to bring in Lord Mawhinney, I think.
We started at the very beginning with I suppose, must have sounded like an accusation that people writing blogs got away with things that if you'd been writing a newspaper article you wouldn't have got away with. And I'm still not clear in my own head how much truth there is to that. You rather neatly ended your article in the Times in September by saying that when in doubt you prayed in aid, what would Kelvin Mackenzie do? I know, Kelvin. It's an interesting question. My question to you is this: reaching out to what I'm still confused about. Look back on what you've written for the last year. How many times have you written something in the blog which, honest to God, you wouldn't have been allowed by Kelvin's lawyers to write, even though you and Kelvin might have had a fairly similar outlook? His lawyers wouldn't have let you write it. Can you estimate how often you've written something in the last year which Kelvin's lawyers wouldn't have let you write if you'd been employed by them, or by him?
Knowing lawyers, I'd say quite often.
Well, you understand the question I'm asking.
Oh, yeah. I think the main thing that wouldn't get past the lawyers that we do is accept a single source. Accept a single source. I think lawyers would say to the editor and the journalist concerned, we need a second source to verify this. And we are more willing to go with one source.
Okay, but humour me. Have a stab at how much you have. Help us, because I doubt any of us have got a clear idea of the answer to this.
The working means that we use is if it's a big story, rather than a trivial story about something overheard in the cafeteria downstairs, then we will take more caution and check it out. You know, if it's going to be a career-ending story, as some of our stories are, then we will make efforts no different from a newspaper to verify it. If it's something trivial and tittle-tattle, we're more willing to go with one source.
Bishop.
One of the relatively few things I think you're all agreed on is that where we are now isn't very satisfactory in legal terms, for different reasons or whatever. And in particular, the role that judges have had through case law in determining what is the law of privacy today is too judge-led. Isn't there therefore a very strong case for a parliamentary look at the whole law of privacy to see if a more democratically agreed framework can be provided, which at least you can all then responsibly attempt, I hope, to work within?
I think the key answer is transparency. A number of people have mentioned this afternoon breaching super injunctions, breaching court orders. The fact is that almost all bloggers have no notice of the terms of those court orders, and it is impossible for them to regulate their publication to know whether they're in breach of a court order or not, because they just simply haven't. They may know there is a super injunction, but they don't know whether what they do will be in breach of that court order or not. And so until self-publishers, and now self-publication can go around the world instantly, are in a position to be able to regulate their conduct by knowing the terms of a super injunction or an injunction of any kind, then there are going to be judgment calls. Then you are going to get people making the call, yes, it's in the public interest, it isn't, because they actually don't know what the terms of that court order are.
Sure.
I would definitely think it needs to be looked at by Parliament. And that's one reason I'm so happy that you're having this meeting today, because it's definitely a mess. I mean, the other thing I would say, I think many of us agree on, is that there needs to be a much stronger emphasis on freedom of speech. The freedom of speech, the balance has been wrong, and I think that's partly where some of the disobedience to these rulings has come from. It just seems like freedom of speech is in trouble in this country. I mean, personally, I would share Paul's view about something comparable to the First Amendment of the US Constitution. I think that seems to work much better. To give an example, if you compare the New York Times' coverage of Trafigura with any UK newspaper's coverage of Trafigura, you'll see a marked difference. And suggest that you do that. And it feels like in the States they've succeeded in protecting freedom of speech far more effectively and far more happily than here. The other thing I would point out on that front is that I use a blogging platform called WordPress. Most of the big blogging platforms are US based, and part of that is because it's very difficult for businesses who want to be internet providers in this country to function in the current environment because the protections just aren't there.
Yeah, I agree. It would be good to know the rules of the game whilst we're playing. It is a bit like herding cats at the moment. It's very difficult to manage. It'd be also, a bit of, as Paul pointed out, we do endeavour to act as if we were a mainstream media kind of, like Paul says, if you do have a big story that is potentially quite damaging to the individual concerned, then you do take certain steps. There are right to reply. You don't, you do approach them beforehand. Well, you do. You do look for more than one source. But there's not much mutual respect coming back from the individuals concerned, and like I say, if there are going to be injunctions and super injunctions firing around willy-nilly, then it'd be good. Everyone needs to get it, because 9 times out of 10, with the footballer one, I got it 2 days later than the mainstream newspapers did, which isn't much use to anybody, really, is it?
I think when we're talking about privacy, what we're really talking about is censorship. And do you want judges to be censors? Now, I don't want to live in a society where judges are censors. And privacy is just a euphemism for censorship.
I disagree with you there.
I've got several more.
Right,
Can I
okay.
bring Gisela Stewart?
When the name Kelvin Mackenzie was mentioned, all I remember is Kelvin Mackenzie saying his first approach was they should never let facts get in the way of a good story. So I hope that wasn't your basic approach to it. But I'm just really intrigued by your line of reasoning. You seem to say at the beginning that newspapers even give you stories which their editors wouldn't publish and let them pass their legal department. But then you pray this great compliance with all the rules in as much as you can find them out. Are you trying to tell this committee that you should be singularly, differently regulated and have a different standard applied to other outlets?
I wouldn't characterise it in that loaded way. What I would say is that if you are going to try and seek to regulate the blogosphere and social media generally, there are 2 questions. First of all, what information are you going to give those who blog and tweet so they can actually form their own contact? And the second thing is, will this regulation be effective?
No, as a starting point for me is, do I say newspapers, radio, television and the blogosphere are part of a media which may or may not be part of a regulation, or are you saying you should be treated differently from those other outlets?
I wouldn't say should, but what I would say is that you may find that you need different regulatory mechanisms to regulate social media than broadcast and publication media.
But the basic way should be the same.
Well, I'm not quite sure.
I agree with my friends. I think we should all be regulated the same, and we should be protected. And effectively, I think the only regulation should be the laws of defamation. I don't think we need media standards, press complaints commission, all these kind of quangos. I want the freest possible press we could have. I think that's in the public interest. And when we get it wrong, then we should pay the consequences in the court.
But as you have got no money, there are no consequences to pay. Can we just the other 2? You also think you should be subject to the same rules that everyone has, whatever those rules are?
I find that a little bit slanderous. I think I've got no money.
Well, Richard Wilson told us it would
I know, I'm taking advantage of privilege. I think the chairman should jump in there.
I'm definitely I'm not myself.
No, just to clarify, the general law of the land, copyright, contempt, defamation, in almost all circumstances will serve the purpose you want it to. So yes, same law for everybody. But if you're going to have any specialist media regulation, you're going to find it very difficult to apply it in the same way to social media as you would do to mainstream media.
It isn't quite the same law for everyone because it's very expensive to bring proceedings. And therefore, it may be those who can bring defamation proceedings are the wealthy people. Regulation might help those who cannot go to law.
Well, the experience of the blogosphere is actually very different from what you've just suggested. The libel cases which have caused the most problems are ones brought by litigants in person. One of them is before the High Court at the moment, where they have no commercial reasoning behind their decision, but because it is so ridiculously easy to bring a libel case in this jurisdiction, they can make bloggers' lives hell for years and lead to loss of houses, loss of income, loss of capital. And so the biggest problem for the blogosphere at the moment is not often the people who are rich, but the people who can just go and be a litigant in person at the High Court and have caused mischief in that way.
I've never been sued by a rich person. Never. I have. Good for you.
We do need to move on. Can I bring in Lord Hollick just before we do?
I want to return to Lord Gold's point about redress. Guido Fawkes is established offshore, which seems to me to rather impair the right that anybody has to redress. So you can publish an article or a blog which breaches their privacy, which by virtue of it being sourced from one source only may be inaccurate, and which can ruin their reputation, and yet they have no right of redress. Are you comfortable with that?
Well, they do have a right of redress, obviously, under the law. I haven't made it easy for them, though, and that's a feature, not a bug, as I'd see it.
Well, is that?
We have a ruinous libel culture. The reason I adopted the obstacles I did was because we wrote a story about someone's dyeing their hair. They went to Carter Ruck. I mean, this is over mocking someone's hair colour, and it caused great expense. And I thought, well, this isn't going to work. And it's very interesting. People tell me the reason there's no city version or finance version of Guido, doing gossip, is because rich people in the city will send off lawyers' letters like that. And that's why the city pages, the diary columns in the city pages, are all press releases. Because the culture, the libel laws in this country are just too easy for plaintiffs to come after us. And, if I didn't have the protections I have, I simply wouldn't be able to function.
Yes, but by choosing to locate yourself outside of the jurisdiction, you effectively give yourself carte blanche to write whatever you wish to, whether it's accurate or not.
As I've explained, I have, Zach Goldsmith and Jemima Khan managed to get me in the courts, so it's not impossible, but you have to be pretty determined, and I don't give in easily. I think, I've got to take what measures I think are appropriate. I'd point out the actual physical hosting of the blog is in the United States of America because I have First Amendment protections there, and because the hosting company has given me assurances that if they get letters from Schillings or Carter Ruck, they will protect my First Amendment rights.
So, if you publish an article which is inaccurate and destroys somebody's reputation, what right of redress do they have against you?
Well, they can sue me.
But you're outside the jurisdiction.
Well, I mean, it's the case that, if you do business across borders, you have to take action across borders.
If you publish within this jurisdiction, then there would be liability. It would be difficult to enforce, but there's still liability within this jurisdiction.
We need to move on quite quickly. Elvin,
I'd just like to make the general point that reference was made earlier on to judges being censors. Well, an injunction is meant to be an interlocutory proceeding. It's a pro tem proceeding until there's a full hearing of the case. And it may be this committee might be considering in due course shortening the period between an injunction being granted and a full hearing. Would that be more satisfactory, do you think?
But the only injunction granted against me was done ex parte. I wasn't even aware that it was being sought.
No, that's not the issue. An injunction is meant to be a temporary proceeding leading to a full hearing. And if, for example, between the date of an injunction being granted and the full hearing of the issues in that case, that was shortened, would that not be a step forward?
That would be good if it could happen. Of course, though, claimant solicitors in the city are very good at getting those interim injunctions, which then effectively become a remedy in themselves because everybody then just gives up and the substantive case then falls away. But yes, the speed to which you could actually get to a final disposal of the case would be very, very, very welcome. And there are problems about these interim injunctions because, as I mentioned earlier, people, especially self-publishers without legal departments, are not able to regulate their conduct because they don't know the terms of those injunctions. And so the speed to actually final disposal of a libel case, without a privacy case, would be very welcome indeed.
Last, very small.
Paul just said that the city has or people in the city have money, so that creates a chilling effect, which slightly contradicts what Jamie said. But you said you hadn't been sued by a rich person. I mean, isn't Lord Gold right that whether we're talking about libel or what we're supposed to be talking about, which is privacy, that it's a law that protects wealthy people at the moment, as to how in practice.
The difference to what Paul said and what I said was that a lot of celebrities have ambulance chaser solicitors that wouldn't go on the no-win, no-fee basis. So therefore, it's no skin off their nose to start firing it out. And we don't have that. We don't have that luxury to do it in reply. Whereas what Paul's saying is in the city, they don't need the no-win, no-fee. They'll just dish it out willy-nilly, so to speak.
We're going to have to move on to our next session. So can I thank all of you very much.